SJC-12528, Commonwealth v. Damian, Linton.
Good morning, Mr. Gant, no relation.
Good morning, Your Honor. That is correct. For the record. Good morning, Chief Justice, Associate Justices, and may it please the Court. Ira Gant on behalf of Damian Linton. As this Court has recognized, and as has been discussed today, Chapter 278A was designed by the legislature as an evidence-gathering process for those defendants, like Mr. Linton, who seek to prove their innocence, seek to prove the truth that someone else killed the victim. Mr. Linton seeks specific tests of specific items because they all could provide evidence of whether he or another man struggled with and strangled the victim. Whether Mr. Linton or someone else deposited the sperm and saliva on the swabs that were collected during the autopsy, and whether he handled the glass or the cell phone as the Commonwealth suggested at trial, placing them next to her body after the murder to fabricate the crime scene. Now, with regards to the individual swabs, the untested swabs and the neck swab, both experts agreed that the newer test he seeks could possibly find male DNA, where it could not in 2006.
If we could distinguish, because I know there's various testing, and I actually appreciated Ms. Langsom's checklist because it helps us to sort through it. So you've got the swabs, you've got the vaginal swab, the external genital swab, and the oral swab.
Correct. I believe the anorectal swab is in there as well, but that's correct. Essentially the sexual assault kit swabs, Your Honor.
And all of those, this is the, okay, that's a better way to frame it. The sexual assault swabs, all of them were tested. Well, or not, were tested with the version then extant of the YSDR.
No, all of them except, I believe, the anorectal swab were tested. But for the purposes of our hearing, yes, they were all tested with what was available at the time or were not tested. And what Mr. Linton is seeking to test nonetheless are the untested portions of the swabs. So in 2006, the state police lab took a cutting of the Q-tip swabs. That is the cutting of the oral swab, for example, that tested positive for the one sperm cell. And it was those cuttings that were sent to Cellmark in 2006 and that were tested with the DNA technology that existed at that time. And so Mr. Linton seeks to test of those sexual assault kit swabs the untested portions of the swabs with the newer technology that both experts agreed and was well established at the hearing could detect DNA where the 2006 male-only DNA test could not.
So your view is that if the more sensitive testing were to identify a male other than Mr. Linton, that would be probative of the fact that possibly somebody else had sexually assaulted her at the time of her killing?
Effectively, yes, Your Honor, but our argument would possibly be that it would be someone who came into contact with her right around the time of her murder and thus may have been involved in the strangulation and the killing of her. And so the medical examiner testified that sperm could only exist in a person's mouth for minutes, if not hours, unless they drank something, and that the victim had died within 8 to 24 hours of them finding her body. And so our argument would be if we're finding another male's DNA on the victim in a home where the defendant and the victim live together, then that potentially provides material evidence that someone else killed the victim.
Can I ask about the sperm evidence, just
Yes, sure.
technically? So this new test, did either of the experts say that this new test could reveal the DNA based on the, from what I understand, it's a very tiny quantity, right? It's like one cell or something. There's the specifics of the sperm test. Was there any, did either expert say that you could get DNA off of that?
No, but I think it's an important distinction, Your Honor, that the piece of the cutting of the swab had one cell that was detected. Mm-hmm. It is unknown how much DNA is on the untested portions of the swab. So like in Clark, we do not yet know how much DNA is on the untested portion of the oral swab or the vaginal swab that tested positive for saliva. What we know is that there could be DNA there. And if we detect DNA of another male, a foreign male DNA profile, then we could possibly find evidence that's material to the identity of the killer.
So does that mean whenever a new test is stronger than an old test, you're going to be able to get DNA test no matter what? That seems to, that's what you're saying.
I think this court answered that question in Donald, Your Honor. I don't think that it's whenever a new test, we get DNA testing. Mr. Linton certainly has many other parts of the statute and the burden that he has to meet, not just that there's a newer test that's available. He also has to show that the test was somehow going to provide, as this court, I'm going to butcher the exact quote, but that this court essentially provides more, the test provides more accurate information as to the identity of the perpetrator than the previous test could. And it was undisputed that in addition to, as the Chief Justice Gantz said, the sensitivity, it was really the greater discriminatory power of the newer YSTR tests. It's not just that it was more sensitive. They testified that PowerPlex Y23 may be more sensitive, and Dr. Ladd said it would be more sensitive, but also that it was testing portions of the DNA chromosome that the Y filer did not examine, did not even look at. So the DNA could appear, and we could find a common profile by looking at these different swabs and looking at the other items he seeks to test as well.
So it doesn't matter that then does it matter that they found on the original test a single sperm cell? Does that get you in the game, or is that unnecessary?
I believe that it matters to the question of the potential materiality of the results. Okay. And so essentially, in our trying to test the swabs, the question is what is the potential probative nature of the swabs? What could they be? When we hear what the evidence that we have at trial is that the victim was strangled for, I believe, a minute and a half. And that a knee was pushed into her side, when here we have sexual assault kit swabs that were taken during the autopsy.
The swab that revealed, as you say, the stray allele?
On the neck, yes, Your Honor.
On the neck. Does that make the rest of the testing symbiotic in that if there is a stray allele suggestive of, if you go to the lower threshold, suggestive of a third party, not the defendant, then the other tests necessarily should be done as well?
That's our argument, Your Honor, yes, and in large part, I think that adds to the possible materiality of the identification of the perpetrator. Now, the motion judge found that testing of, I'm sorry, Your Honor.
And we'll put aside for a second the water glass and the cell phone, because there's chain of custody issues which you'll discuss.
Yes, Your Honor.
But on the other pieces of DNA, is it your argument that, well, if there's a stray allele in one very incriminating place, or exculpatory, obviously, if you're a client, but incriminating for a perpetrator, then the rest of the DNA should be looked at under the more sensitive testing?
The rest of the DNA in this case?
Right.
Yes, that is our argument, Your Honor, and in large part because if we're testing these other items, all of the items that we asked to test, in fact, including the hair, the questioned hair sample, if we test these other items and are finding a consistent foreign male DNA profile, then that is potentially material to the identity of the perpetrator, that someone else killed the victim. And so in assessing what is possibly material when you're looking at 7B4, I think there's a difference in getting to the question of all these other items, as whether you're just testing we wanted to test the DNA extract of the neck swabs versus asking to test these other items. In this case, and it's not necessarily going to be that way in every case, what we have here is the Commonwealth's theory, our theory, and seemingly the evidence supports that there was one killer. Not that there's going to be other people involved, but that there was one killer and that there was a male that killed her. It's the Commonwealth's theory that it's Mr. Linton. It's Mr. Linton's position that it's not, that he was innocent. And so if we test these other items where we found sperm, which would be evidence of a male being in contact with the victim, and we test these the other swabs as well as the other items.
You said it's a foreign sperm cell that does not match the defendant?
The sperm cell, using the technology in 2006, returned no results.
No results.
In 2006, it was not enough DNA in one sperm cell to result in a profile at that time.
So it was inconclusive?
Effectively, yes, it is inconclusive, but the way that Cellmark reported the results is that there were no results. But yes, it was inconclusive because they tested positive for sperm with confirmatory testing that it was sperm, and then the DNA returned to no results. What I wanted to address Justice Gaziano's point is that the motion judge found that the testing of the swabs would not likely yield any results, in part because the 2006 testing resulted in none, and the neck swabs resulted in these lower threshold allele, or this lower.
I think you point out that the Cellmark and the FBI say that when they want to, they can go down to the 50
Correct, we
threshold
pointed that
limit.
for exculpatory purposes. But part of our argument, of course, is that that's presuming that we're going to get those low-level results on the untested swabs. We don't know what remains on the untested swabs. We could get full profiles, and that was what Dr. Ladd testified to. Both the Commonwealth's expert and the judge ultimately articulated that they just didn't feel that we were likely to get those results. But Chapter 278, as this court has gone around and around about in the earlier cases, is not about likelihood. It's about what is possible. In Wade 2, the court found that the issue is, could we get these results? And if we could get the results, then you get testing. And that's Mr. Linton's position.
Let's discuss that possibility, and let's move to the drinking glass and the cell phone, because I understand your point that if there is a possibility that there could be non-Linton sperm in the vaginal area or another as part of the rape kit, that would be a big deal. But if you find another bit of DNA on a drinking glass which has been touched, or on the cell phone, which arguably she could have lent to somebody else, why is that a big deal?
Because the Commonwealth made it a big deal at the trial, Your Honor. I don't think this is a situation like Mr. Moffitt's case, or as this court was discussing about collateral pieces of evidence before, where we're just asking to test items that have been picked up as part of the investigation. Certainly the police pick up all kinds of investigation, but here, the Commonwealth's own words to the jury, the trial prosecutors, was, how were this glass and these cell phones still in place, and how was the water not spilled if the defendant had not put them there until after the murder? Because the argument was that he had strangled her so violently that they would have been upset, and so he must have put them there afterwards to fabricate the crime scene. And as this court found in Moffitt, we don't have to draw a straight line from testing the evidence to exonerating Mr. Linton. All we have to do is create a link in the chain of showing materiality, potential materiality. And as we've already discussed, if we test those items, I agree with Your Honors, the question and the problem of who else could have potentially touched the cell phone. But if we test that cell phone and the glass and say we find a foreign male DNA profile that is, again, consistent with what's on one of the swabs, then that answers the question of potential, what is potentially material.
Yes, then the question is, do you go sequentially? Because if you find nothing on if we were to allow you to do the sexual assault swabs and you find nothing, the fact that you find DNA on the other stuff is probably not going to amount to anything consequential, given all the chain of custody issues.
I would disagree, Your Honor. I would think that there are cases where that may be the situation, but not here. I think that Mr. Linton's, because those items, the cell phone and the drinking glass, and then the latent print lift, which is also discussed in the chain of custody section of the motion judge's decision, excuse me, that testing those items have independent potential materiality here than just the swabs. There certainly could be cases where testing things in phases are necessary, and in fact the statute provides for that. If you test to some batch of evidence and underneath that you get inconclusive results, you could seek more testing under, I think, Section 13, it occurs to me. But here, what we have are items that were directly related to the crime itself, that Mr. Linton fabricated the scene. So whether we find another male's DNA or we find the absence of DNA, it could provide a link in the chain to further Mr. Linton's investigation into his own innocence. And that's the purpose of Chapter 278A.
Can I ask, can I ask about the hair?
Yes, Your Honor.
So do we know whether or not there was, I can't remember, there's a factual issue about whether the hair was able to be analyzed for DNA, right? Whether it's got its root, right?
The motion judge found, although there was no evidence whatsoever in the record, that the hair was not tested, presumably because it has no root. But we have no knowledge of whether the hair has a root or not.
Okay,
But,
so when we go through this record, we're not going to know the answer to this question whether it has a root or not.
no.
And I also understand that you can't compare mitochondrial DNA to the other kind of DNA, right?
That's correct, Your Honor. You can't compare the results of mitochondrial DNA analysis to STR or even YSTR analysis. Instead, you have to independently test the known samples with mitochondrial DNA analysis. So test Mr. Linton's and test the victim's known DNA samples to compare to the questioned hair profile if it does not have a root.
So in this case, there's obviously going to be plenty of reason why you're going to find the defendant's hair. So if when they test the mitochondrial DNA and compare it to his mitochondrial DNA and they're different, that's enough? In your view, that's a material, there's material potential there?
Because the hair was found on her body. If the hair was found somewhere else in the bedroom, or if the hair was found in the living room, I would agree that we would have a serious potential materiality argument here, problem with our argument here. But because the hair was collected from her body during the autopsy, and because the argument from both the medical examiner and the Commonwealth was that the perpetrator, the killer, was on top of her, putting his knee in her chest and strangling her, then yes, I think that if we find another DNA profile, then yes, that adds to the possible materiality that we could further investigate. With the remainder of that, I rest on my brief. Thank you very much, Your Honor.
All right, thank you. Ms. Langston.
Good morning, Mr. Chief Justice, and may it please the Court, Jessica Langston, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. There was no abuse of discretion in Justice Laureate's denial of this 278A motion. This was an experienced Superior Court judge who presided over the first-degree murder trial of this defendant, was aware of both the investigative steps and the evidence that came in at trial as a presiding judge, ruled on a motion for a new trial that the defendant filed subsequently, followed the statute, followed Section 7, considered all the prongs, held an evidentiary hearing, and I would suggest implicitly credited the Commonwealth's expert, which is really evident from the judge's order, applied the correct standards, cites the 278A cases, and is familiar with those cases.
I don't get how we get around the fact that there's potential to discover other DNA in the neck residual enzyme, whatever the terminology is, that the original test indicates there's something below in the 50 range as opposed to the 100 range, and it's another male, potentially, and this test is more sophisticated. Isn't that significant?
Well, Your Honor, if I could just explain. The results of the testing by Cellmark, and as Cassie Johnson from Cellmark, who is a forensic DNA analyst, testified at the time of trial, there were no DNA results, no results. The defendant was excluded from...
But that's a that's an
No
overstatement.
results at their threshold.
No results at that threshold.
Right.
And as Ms. Walsh, who is the Commonwealth's expert, who is the technical leader of DNA at the Massachusetts State Police Crime Lab for DNA and CODIS, explained that in order for an accredited labs have to come up with their own validation. So whenever a new kit, a new STR, by STR I mean a full DNA profile, XX or XY, not just Y STR, which is only the male chromosome, which was done in this case. But when a new kit comes online, these labs have to validate that kit on their own instrumentation. That means they run the test, they look at what the procedures are by the manufacturer of the test to see what are the parameters, and then based on that, they set their reporting threshold or the calling threshold when we're talking about YSTR. Ms. Johnson testified that the calling threshold was 100 RFUs, relative fluorescent units. And
That's under the old or the new?
This is the testing that was done around the time of trial, so the old test.
So the old one, everyone agrees that the old one, they wouldn't report anything unless it's 100, right?
That's correct, Your Honor.
But the new test is more sophisticated, right?
Well, and just briefly, Ms. Walsh testified at the hearing on the 278A motion that she would not go below what the validation was, whatever the calling threshold was from that lab, because it's based on that lab's instrumentation. What the new STR tests are is that they include additional loci. So here we're talking about Y-filer, which incidentally the State Police Crime Lab uses to this day. We're talking about YSTR tests that now get 23 or 27, so additional loci. But Ms. Walsh testified that the 17 loci that were tested in Y-filer, the results remained the same. She also testified that with respect to the untested portions of the swabs, so if I could divide the evidence that the counsel or the defendant is seeking to test into three categories: the untested portions of swabs that already got DNA testing for which no results were found, so the defendant is excluded, and the neck extract, which is all that remains that he seeks to retest, and then these other new items. But for the untested portions of the swabs, Ms. Walsh testified that the policy of the State Police Crime Lab is that if nothing is found on the portion of swab, that there's an assumption that nothing will be found on the other portion.
I get that argument, but let's get back to what Justice Kafka asked about the thresholds. So at 100 RFU, they report no results.
Yes, Your Honor.
But I thought the evidence was that either the FBI and/or Cellmark have the ability to go below 100 to 50 for exonerations, and according to LAD, if you go to 50, there's an allele that does not match, a male allele that does not match the defendant.
That is what Dr. Ladd testified to.
All right,
However,
okay, what's the however?
the however is that in Cellmark's operating procedures for I think it's their YSTR interpretation guidelines, you can only go down to 50 if you request it from the technical leader, and I think it's in extreme circumstances. That's the quote from their manual. I believe it's Exhibit 15, which is a Cellmark Standard Operating Procedures at Record Appendix 244. And as Ms. Walsh testified, Cellmark didn't do that.
But
Cassie
I
Johnson didn't
guess
do
that's
that.
circular, because that's a private lab, and what they're saying is in extreme circumstances we'll do this, and one could probably argue, and I'm sure Mr. Gann, if he had a chance, would argue, if we asked him, that an exoneration is an extreme circumstance.
Well, Your Honor, I think that these are sort of taking this phrase and applying it in a totally different context.
But
So,
I guess what I'm trying to point out, or trying to ask you, is if 50 is possible, and it is, according to Cellmark in certain circumstances and according to the FBI, why wouldn't you accept the proposition that if you go to 50, the inference is, or the evidence from LAD, is that there's a stray allele, which is very problematic from another male?
well, and Your Honor, I think the answer to that really gets back to when I was explaining before, when a lab has a new kit and they validate it and they establish the calling threshold. What the calling threshold is when we've tested this kit on a lab, what's the reliable DNA? And they've determined that the only thing they can say is reliable DNA is what is above this calling threshold, so anything that's above 100. Anything below that, at this 50 or whatever, at the 64 RFUs, if you lower
No,
it-
they're
right.
saying it's noise.
So it's-
I get that, but
Right, so it's really a difference in the manner in which, well, there was testimony too of Ms. Walsh that she wouldn't look below. You would rely on another lab's validation and their
What does
calling
the
threshold.
FBI use? Is the FBI threshold 50 or is it 100?
The FBI 2002 protocol, I think, I can't recall exactly what it is, that was in evidence. Again, regardless of what the FBI threshold is.
I mean, is the FBI, I remember reading somebody suggested the FBI goes down to 50,
I
right?
think it was my brother, Your Honor, and I have the exhibits, I'm happy to look through them to answer that question.
Okay, but so if the FBI uses the 50, does that matter?
Well, it does matter because it all gets back to, and I'm trying to think of a good analogy, what's the validation threshold for this lab? Different labs have different thresholds depending on their instrumentation. Some have older instrumentation, some have newer instrumentation. And in fact, part of what Ms. Walsh also testified was that she was trying to compare PowerPlex Y23, which is one of the defendants, one of the cases.
let's use points of, and I know that they don't use this because they don't want to, but let's look at points that people would use, points of comparison for fingerprints. All right, so
Okay.
suppose a lab says, we're going to make a match on a fingerprint when there's 8 points. And if it's 7, no match. And then another lab says, well, we're going to use 5. And then someone comes up with potential exoneration, says, we have 4 points. And then they want retesting. We're going to say, no, you don't get it because you only have 4 points. I don't get that. Where there is some validation to use 50 RFU by Cellmark in extreme cases, and I think by the FBI, and we'll check the record on that. Why that isn't significant evidence to allow us to look further.
Well, Your Honor, and I think it's because if you're looking at a fingerprint, you're looking at kind of a distinct picture with a definable number of points. When you're talking about DNA interpretation, as the court's aware, it's a complicated process. So of the 4 steps of DNA analysis, interpreting the results is really the most difficult part. And critical to interpreting the results is where you set your thresholds. And currently, though not previously, because Ms. Johnson never testified to a lower threshold, but there's evidence in the record that there's this calling threshold for YSTR, and then there's an analytical threshold. So sort of how can we use the DNA in between here to determine whether or not we can exclude someone? Ms. Walsh testified that you can't exclude someone on the basis of one below threshold allele that differs from what the defendant's profile is. So I think that DNA is much more complicated than just a fingerprint with, we have half a print, how many points do we have? It really requires kind of an understanding of reading all of the results are possible, interpreting them, reading them in conjunction with each other.
But where I'm confused is it would be one thing if Judge Laureate, who we all agree was a very fine judge, or was a very fine judge before he retired, had said, even if they had found this, it would not be admissible in evidence. But I believe he did say that I'm going to at least assume for the sake of my decision that it would be admissible in evidence if they had found it below the 100 threshold. So what do we do with that?
I think, Your Honor, that what Justice Laureate ruled was that the defendant had met, I think it's 7B6, which is that the results of the testing are admissible. And that goes to, as the court has said in Bazanowitz or in other cases, is YSTR a reliable method of analysis? What kind of hearing do we need to go through? I think that's what
And
the
that's
ruling-
all he said? All he said was that in general, YSDR is
I think-
admissible, not that if what the defendant claims arguably or potentially could be found is found under the more, the new testing at a lower level, that would be admissible? You say he didn't say that.
Your Honor, my recollection is not that he said that. In fact, his ruling with respect to whether or not this type of analysis would be admissible in the courts of the Commonwealth was in his order denying the motion for reconsideration, where he ruled, I think, that with respect to, I believe it was 7B6, that the results of the requested analysis are admissible, and 7B5, that the purpose of the motion was not the obstruction of justice or delay. So the focus was really on 7B3, incorporating 3B5. 7B4, and as the court's aware, 7B2.
Could you point
That
us,
was the focus of the ruling.
could you point us to where it is that you say it's so evident that the judge credited only your witness?
Well, Your Honor, I would suggest to the court that a reading of the entire transcript in conjunction with the judge's order shows that the judge implicitly credited the Commonwealth's expert.
Not at all not at all the defense expert?
Well, I think there was a lot of testimony on which they overlapped regarding testing, regarding sort of general understanding of DNA. But when it came down to it, the judge's rulings really reflect, although the court didn't make an explicit finding that he credited Ms. Walsh's testimony over Dr. Ladd's, the judge's rulings really reflect that that, in fact, is what happened. Because, for example, with respect to these untested portions of the swabs, the court concluded that the defendant didn't meet 7B4, which is that the requested analysis has the potential to result in evidence that's material to identification of the perpetrator. Ms. Walsh had testified that the judge, concluded that another portion of the swab may provide a detectable sample has, quote unquote, no scientific support. Dr. Ladd had testified to that. The Commonwealth's expert, Ms. Walsh, had testified that the Massachusetts State Police lab policy is that swabs are taken homogeneously, so that another portion of if one portion of the swab yielded no results, so the defendant was exculpated, another portion of the swab would yield the same result, which would be the same result. And that's at the January 29th, 2016 transcript at pages 168 to 170.
Did either of the experts, the judge makes a finding on the neck evidence that the PowerPlex Y23 and the Y-Filer Plus do not represent material improvements, right?
Yes, Your Honor.
Did either of the experts agree with that?
The defense expert
Didn't
disagreed
think it was a
with that.
material improvement?
Well, the Commonwealth expert acknowledged that it tests additional loci, and I know that this
It
court's...
also detects smaller amounts, right? It can detect smaller amounts and additional loci, right?
Well, that was the defense expert's testimony, and I think Ms. Walsh had testified.
Did the Commonwealth's expert disagree with that it does both of those things?
Well, Your Honor, what the Commonwealth's expert testified to is she recognized that it detected more loci, but she also,
And what did she say about detecting smaller amounts?
she testified, Your Honor, that PowerPlex Y23, which is one of the tests the defendant sought, and Y-Filer, which was the YSTR test used at the time of trial, used the same
I'm
interpretation
asking about
guidelines.
Y-Filer Plus. We've got both PowerPlex Y23 and Y-Filer Plus, right?
Yes, Your Honor. And so PowerPlex Y23 tests 23 loci, Y-Filer Plus tests 27. Y-Filer, which was used at the time of trial, tests 17. And what Ms. Walsh testified is she compared PowerPlex Y23 to Y-Filer, which was used at the time of trial. She saw that they used the same interpretation guidelines, which led her to believe that they had similar sensitivities. And she looked for a study, and she could not find a study comparing Y-Filer tested on older instrumentation, as had been done in this case for the 2006 trial, with newer tests on newer instruments with the newer tests on the newer instruments. And so based on that, she couldn't evaluate the value of PowerPlex Y23.
And
at the
that's why it's
January-
different from our prior case law, right? And that's your position, because we've said more sophisticated testing fits within the statute.
Well, more sophisticated testing, Donald has said that more loci or more
Right,
sensitivity.
when we went from PCR to, we went from RFLP to PCR to other forms of PCR, right?
Yes, Your Honor.
And I assume as we go further down this, the statute is meant to give people the benefit of that doubt. But what you're saying is it hasn't been that much of a jump between these two types of tests.
I'm saying, and that's what Justice Lauria concluded, and there's evidence in the record to support that. And I would also, in terms of,
And what do you say to the proposition that if we were to conclude that the neck extract should be tested, that there's some symbiotic relationship between a stray loci and that, and then the additional testing sought in this case?
well, I mean, with respect to what's the most probative evidence in this case, Justice Laureate had indicated or ruled in the order that there was no evidence in the investigative stage or the trial that the victim had been sexually assaulted or that any area of her body had been touched. So the judge denied testing as to the anorectal swab, and I would argue to the court that there's no evidence. So the anorectal swab, the vaginal swab, the external genital swab, where there's no connection to the crime, these are really more like the Socks and Clark.
But what do we do with the sperm in the mouth evidence, right? There's, whether there's a sexual assault or not, there's some type of evidence of sexual conduct, right?
Well, there's one sperm cell was found in the victim's mouth, yes, Your Honor.
And we also have testimony that it doesn't last very long.
That's correct. My brother accurately represented what the trial testimony was.
So I guess if it doesn't last very long and more sophisticated testing may make a difference. I don't know if it does here. We have to read the record. What's the testimony on whether, from the two experts, on whether further testing of the sperm will be able to identify whether it's the defendant's or someone else's?
Well, I don't recall specific testimony from the experts as to the sperm, and I think that then goes back to the defendant's burden of proof. So the burden of proof by preponderance of the evidence, while admittedly a low standard, as I've cited in my brief, Sargent versus Massachusetts Accident Company, it's not a doormat. And that case says that the weight or preponderance of evidence is its power to convince the tribunal, which has the determination of the fact of the actual truth of the proposition to be proved. So the defendant, I can't recall exactly what if at all, how much genetic material was present there, but there was no evidence on that. And that's
Well, we know there's a male sperm cell, right?
Yes, Your Honor.
It would be really important if there's some other male she's in contact with in that very short time frame we're talking about, right?
I'm not so sure how important it would be, because the prosecutor also asked the medical examiner or elicited from the medical examiner that if the victim had not had anything to eat or drink, the sperm cell could have lasted for a longer time, not just this sort of minimal amount of hours. But I need to go back and check the transcript on that.
Okay, how about the last one, your favorite subject, preserving evidence in the clerk's office.
Yes, Your Honor.
So what do we do now with this? Especially given last month's argument, which I know we can't do, but this is a potentially significant issue, whether the preserving of objects is reliable. If the Commonwealth, basically, we don't have to test because the Commonwealth's done a really crappy job of preserving it, where does that lead us?
Well, I think it's clear from last month's argument, or from the state of things now, is that in clerks' offices, only the assistant clerks handle the evidence. They wear gloves, and the evidence is now preserved in a different manner than it was previously. I will say
in this case, we have, okay, it's a cell phone in a box. Even if they only wear gloves, we've got problems, right?
Yes, Your Honor. We have problems with handler DNA, as testified to by the Commonwealth's expert at this hearing, and even acknowledged by the defense expert at this hearing. The items and the photograph of the evidence in the box was admitted at this hearing. I recently checked on the evidence. It's all, not that it would matter, but it's all still together in the box. And in addition to that, we had testimony. There was a Mass State Police trooper, and now sergeant, who had indicated that the cell phone was seized by an unknown police officer and then given to her.
No,
and that,
I get that. I'm just
Yes.
trying to understand whether we're rewarding poor preservation here. If your argument is we can't rule out that someone has touched this and messed up the chain of custody, but if
Yes.
we know that every physical object is not being preserved properly, does that mean the Commonwealth is getting all of these objects saved from further testing by doing a poor job of preserving them? I'm just trying to figure out where we go with this.
well, it's, as the defendant argues, he doesn't have the burden to prove a negative, but that's not the standard that the judge applied, and that's not what the statute says. So the defendant had the burden of showing by a preponderance of the evidence that the evidence under 7B2, that the evidence or biological material was subject to a chain of custody sufficient to establish that it has not deteriorated or been handled such that the results would lack any probative value. And I'm suggesting that here he did not. He could have called someone, say, from the crime scene services
But
section.
normally when the Commonwealth, we're all one big Commonwealth in a sense. So normally when the Commonwealth doesn't do something it's supposed to do, it doesn't benefit from doing it poorly. But you're somehow suggesting they do here.
Well, Your Honor, once the cell phone was entered into evidence, then it's a fair inference, and this is the inference that Justice Laureate made. It's touched by either the prosecutor, by the witness, by the jurors. This case got sent up to this court, as Your Honor, Chief Justice Gans wrote the opinion on direct appeal in this case. And Justice Laureate even suggested in the November 30th transcript at page 85, like, what are we supposed to do? Start testing male Supreme Court justices? So it's a fair inference that this was handled by a lot of people, the cell phone. And once the item has been entered into evidence, then it's the responsibility of the clerk's office, or it's the responsibility of the court. So it's not the prosecutor's office that's trying to benefit from this. It's sort of changed jurisdiction, if you will.
I can ask you one more question.
Yes,
I know
sir.
your time is long gone, but 7B4 speaks about the potential to result in evidence, and then you have 7B6, that the results of the particular type of analysis being requested have been found to be admissible in courts of the Commonwealth. So what do we do, or what is a judge to do, if a judge says YSTR is admissible, but so far judges have not allowed YSTR with the 50 or the below 100 standard to be admitted, but we don't know whether or not they might in the future. How is a judge supposed to handle what would be a Daubert question?
Well, it would seem that the court, I would suggest, Your Honor, that the court could conduct a Daubert-Lanigan hearing at that time
Part of a Section 7 hearing?
to make the determination in order to have information, unless it's unless it's clear in the case law that this is a type of test that's been deemed admissible in the Commonwealth, it doesn't seem unreasonable. And in fact, that would be part of this. That would be part of the Section 7 hearing. It would be Section 7B6.
To say that this evidence, even though it may not have been previously being viewed as admissible, would be or would not be admissible based on the judge's finding of Delbert Lanigan.
Yes, Your Honor.
All right, thank
I
you.
know further questions. I'll rest on my brief. Thank you.